required to bring an urgent motion?
If you feel you're in a situation that you can't wait to get
Yeah.
before a judge on a case conference to get the order made. So as I said, what you have to do is to show the court the reasons why you cannot wait until after your case conference to bring this motion.
Right.
So what you do in your motion is you prepare, like you would with any motion, a notice of motion, which is a Form 14, and the 14A affidavit in support.
Right.
When you do your notice of motion and the affidavit in support and you bring them to the court staff,
Yeah.
it will be triaged because there are flags that court staff are trained to look for. In some jurisdictions, they will take a draft notice of motion and a sworn affidavit, and they'll put it up to a judge to review and to see whether the judge agrees this is an urgent or emergency motion or not, whether the other party needs to be served or whether it can proceed on a without notice basis or what we call an ex-parte basis, and see how it goes. So there's always going to be, once you do your notice of motion and the affidavit, you have to bring it to the court office because you'd be leaving the date and the time blank for when the motion is to be heard, because the court has to be able to fit you into a schedule at some point. And they will triage the motion to see whether in fact it does meet the requirements for an urgent motion.
Right.
Okay, now, emergency or an urgent motions are really not that common. They're not meant to be used on a day-to-day basis. They're really meant to be dealing with emergency, urgent situations. So you can only, okay, so what we're going to do, as I said, there are two ways that an emergency motion could be gotten. Again, I really, really strongly recommend, if you really feel you think you need to bring an emergency motion because you can't wait to get to it until you've gone through your first case conference with a judge, whatever your proceeding is, you should really, really talk to a lawyer. Because first of all, the lawyer will be able to advise you whether in fact what you do have is an emergency situation that warrants bringing a motion. And then even if it does look like it's a situation where you should be bringing an emergency motion, whether it's a type of motion where you can proceed on a without notice basis to the other party, or whether you have to serve them with the documents and give them a chance to respond, but it would still be heard in relatively short order.
Right.
So what we're going to do first is walk through, when you do have an emergency motion, the most common one is the court is going to require the other party to be given notice.
Right.
Okay. So we're going to deal with emergency or urgent motions that are brought on notice to the other side. So the other side gets to see what you're asking for, gets to see the facts that you're alleging, and they'll have the opportunity to file their own materials and appear and argue on the motion as well. But it will, as I said, generally get scheduled within a week of when the motion is brought, because it's something that has to be dealt with right away, or else it wouldn't be an emergency, right?
Right.
So you can only bring an urgent motion with notice in very few situations. You have to show that one of the following is true. One, that your situation is urgent, or that you will face a hardship if you have to wait to bring your motion until after a case conference. And it has to be a very severe, extreme type of hardship. Or the third one, that is in the interests of justice, that your matter be heard before a case conference. So those things are pretty broad in general, and they can cover a lot of territory. But it does show there has to be some reason that triggers why it needs to be dealt with now, as opposed to letting it wait until after you've had your case conference. When you bring your draft notice of motion and your affidavit to the courthouse, the court staff will review it. As I said, it might even be put before a judge to review to determine if you've proven that one of those things exists. Different examples where those situations come up is your situation is urgent because there's an immediate risk that your partner will take your children away or seriously harm either you or the children. If there have been threats made, either to remove the children or to hurt the children or to hurt you. Or that you will face hardship if you have to wait to bring your motion until after case conference because you literally have no money to pay the mortgage and the bank is threatening to foreclose on you. And the other party has emptied out all the bank accounts. Just the fact that you might not have any money isn't going to be enough. And it's not enough to say, well, if I don't pay my mortgage, I'm going to go into arrears and the bank's going to take action against me. If you're in a situation where you're in serious danger of having the bank foreclose on your mortgage because there's no money, you have to be at that point to make it an urgent situation. Which means you'll have probably been going through a process and missing payments with the bank for a while. It's just not, you can't say, oh my God, this is urgent because I'm going to miss a mortgage payment. That's not enough. The bank has to be threatening to take action against you. So that's, like I said, they're tough.
Yeah.
For an example of a case that might be in the interest of justice, that you hear your motion before a case conference. It may be because you have a parenting agreement or an order in place, but the other parent is withholding the children. And if the order or agreement, if you've already got an agreement or an order in place,
Yeah.
or the two of you have worked out a deal for when each of you is to have the children, then the other
Right.
parent just unilaterally says, nope, I'm holding the kids. You're never going to see the kids again.
Right.
I'm not going to return them to you this weekend.
Right.
So those are usually the types of things that you look at when you're doing an urgent motion with notice.
Mm.
The more extreme type of an urgent motion is one that's done without notice, or as we say, it's an ex parte motion.
Mm-hmm.
So what that means is when you bring this kind of motion, it's such an urgent situation that you don't give the other party notice
Right.
that you are actually going to go ahead and bring the motion.
Right.
What this means is you don't serve your partner with the court documents, and they don't have a chance to respond before you go before a judge asking for a decision.
Right.
The party may be able to respond afterwards, but the court can make a decision just based on materials filed on the without notice basis.
Yeah.
And then later hear from both parties about whether to change that decision, because any order that's generally made on an emergency basis will normally only be temporary in nature in any event.
Right. Right.
And if you're dealing with a situation where the other party wasn't even given notice that you're asking the court for this order, if the court finds that kind of urgency exists, they will make an order, but it'll even be more temporary than the one if the other party had
Oh,
notice,
okay.
because it'll say, I'm going to make this order now
Right.
to protect the situation as it stands, but I want the parties back in front of me with the other side being served and with the other side then having a chance to say something, but I'm making an order right now just to get something done between that return date happens. Types of examples for these really, really end of the scale type of urgent motions
Right.
is, for example, if you in your affidavit, you have facts and proof that if the other party knows that what you're asking for, that there's an immediate risk that your partner will either seriously harm you or your children, or that there is an immediate risk that your partner will leave the province with your children and not bring them back. And serving your partner would give enough notice and time for them to be able to leave the country with the children.
Mm-hmm.
It can also be a situation where serving the motion could lead to something serious happening. For example, your partner might take all of his or her money out of the country, so you can't get in any of it. But you have to show that there's a real risk that this can happen if the other party knows you're asking for a court order that doesn't allow them to move their money out of the country. And usually financial motions on an emergency basis are a lot harder to convince a judge they have to make an order on than if they do with things dealing with parenting of kids. So you can actually bring a motion without notice at any time during your court case. So even after you've had a case conference, if one party does something that puts the party that feels they need to get an order at risk or puts the children at risk, you can ask for an ex parte motion at any time. Even after you've been going through your court proceeding, you might be in the stage where you've even had your trial management conference and you're waiting for trial and something happens. You bring an ex parte motion at that point too. You can start sometimes, as I said, you could bring an emergency and then an ex parte motion before you've even started any court case. But if you bring a motion before you've had a case conference, you do have to show why you can't wait until your case conference has occurred in order to bring the motion. So the first thing that happens is so you've got to decide whether this is a situation where your emergency motion, is it a situation where it is so urgent you shouldn't even give the other party notice and you're just going to proceed on your own? Or is it going to be a motion where you're going to serve them, but it's going to be coming up really, really soon and you haven't had your first case conference yet? So once you do those and you bring those materials to the court, there are two things that the court's going to look at first of all. One, whether your motion will be allowed to proceed, because as I said, the court staff or a judge will triage your motion to see if in fact it is, based on the materials, an urgent matter that should be heard. And then secondly, if your motion is successful, then what will the order say? And any order that is made will only be a temporary order. And as I'd said before, that order would only apply for a very short period of time. Usually it's unusual to get a temporary order made on an emergency motion that'll be in effect for more than 14 days, because the court is going to want the parties to be able to file material and to hear from both sides before they do anything that happens on a long-term basis.